Welcome to Simply HIPAA, Protecting the Privacy of Health Information module. This course is provided for you by Educare, a division of Mirabel Management. My name is Kelsey Broadshow, and I am going to be your facilitator. I am an attorney who assists healthcare clients with HIPAA implementation and other healthcare compliance needs. HIPAA is a federal rule that protects the privacy and confidentiality of patient, resident, and client health information. This session will provide an overview of federal HIPAA requirements and give examples of how the rules apply to employees working in health-related settings. The learning objectives for this module are to describe basic principles of the HIPAA regulation, understand what obligations health-related organizations have to protect client health records, explain the rights clients have related to their own health records, give examples of how the HIPAA regulations apply to employees, and describe what breach notification means to you and your responsibility for reporting it. In early 2013, the Department of Health and Human Services and the Office of Civil Rights released the final HIPAA Omnibus Rule. This rule includes the Privacy Rule, Security Rule, Enforcement Rule, and Breach Notification Rule. Under the final rule, all healthcare providers must ensure that their employees receive organization-specific training on topics such as policies and procedures, access controls such as password-protected logins to computer software, breach reporting, and disciplinary guidelines. This module is intended to be an overview of the federal regulations. However, without customization, it does not provide organization-specific information required under the final rule. If you choose to customize this module, we will provide more in-depth information that is required for each organization. If you choose to forego customization of Simply HIPAA, please be aware that more training about your specific policies, procedures, and compliance is required to comply with the final HIPAA regulations. The Health Insurance Portability and Accountability Act, known as HIPAA, is a federal law that protects the privacy and security of protected health information. All healthcare providers and their employees must comply with HIPAA to protect client health information according to federal standards. Some states have additional laws and regulations that provide extra privacy protections. Your employer will alert you to any additional laws and regulations in your state that you need to be aware of. HIPAA protects the privacy of clients. Individual information is often used for providing treatment and receiving payment. HIPAA describes the steps health facilities must take to protect health information. When individuals seek care and services, they trust their healthcare providers to safeguard their health information from unintended uses and disclosures. They expect that their personal and sensitive information, including health information, will only be used for appropriate purposes, such as providing treatment and receiving payment for those services. Not only is it the law, it is also the expectation of your clients. In order to maintain the trust of your clients, you must take appropriate steps to protect their information. HIPAA applies to entities known as covered entities. This includes healthcare providers and health plans, such as hospitals and clinics, nursing homes, assisted living, adult day centers, home health agencies, and hospice, pharmacies, health insurers and HMOs, and Medicare and Medicaid programs. HIPAA also applies to organizations that contract with health providers and health plans. Often, health providers will contract with organizations such as transportation companies, therapy agencies, management companies, or consultants who perform services on their behalf. All organizations that provide these types of services must also comply with the HIPAA regulations to protect health information. All entities covered by the HIPAA rule must comply with the requirements to protect health information. This means that all information they receive, maintain, or create is protected health information. All personnel of healthcare facilities must comply with the HIPAA rules. This includes all healthcare employees, facilities management, volunteers, students, new employees, and contract workers. We all must learn and understand the HIPAA rules because we all have the obligation to protect the privacy of our clients at all times. Your obligation to protect information applies when you are at work. It also applies during your personal time. You may not disclose information about clients outside of work. Protected health information is commonly referred to as PHI. PHI is a very broad concept. It includes all information that is related to the past, present, or future health condition and healthcare services of an individual client, if that information can identify the individual. It also includes information about healthcare services received and payment for those services. PHI is very broad, Any information that relates to an individual's health status is considered PHI if that information can be used to identify the individual. This applies to all information that is documented in a client's health record. Demographic information such as names, addresses, telephone numbers, birth dates, and social security numbers are PHI. PHI includes email addresses and other electronic identifiers. All treatment information such as dates of service, treatment notes, physician orders, and health histories are PHI. PHI also includes various identification numbers that can be traced back to the individual client, such as health plan member numbers, Medicare numbers, license plate numbers, and serial numbers found on implantable medical devices. Additionally, photographs that can be used to identify the individual are PHI. This includes photographs of clients' faces, as well as photographs of wounds or scars that could be used to identify the individual. PHI can be written, electronic, and verbal. That is why it is important to understand your obligations as the employee of a health facility to appropriately protect the information you use and disclose. In addition to written PHI, such as a client face sheet, treatment plan, or assignment sheets, all electronic information about a patient is PHI. For example, electronic medical records or emails with physicians are PHI and must be protected. That is why passwords and screensavers are important when working at shared computers or computers that are in areas that can be seen by clients or visitors. PHI should never be left where other staff, clients, patients, or visitors who are not authorized to view it may see it. PHI is also any verbal or oral information that is shared among coworkers or with clients or patients and their families. You must always take care not to share information with individuals who are not authorized to hear it. Additionally, it is important to use soft voices when talking with coworkers and always speak with clients and patients in private areas. This is also important when using telephones to ensure that the person you are talking to is authorized to hear the information you share. Additionally, use caution when leaving PHI in voicemails. HIPAA provides a standardized method for protecting health information. It ensures that the only people who are authorized to use or disclose PHI have access to it. This means that some personnel in a healthcare facility may be authorized to use information that other personnel are not authorized to use. For example, a billing office employee is authorized to see a client's billing record in order to process payment for the services provided to the client. The receptionist or a caregiver is not authorized to see that information because it is not necessary for him or her to do their job. Likewise, a nurse or caregiver is authorized to see the client's treatment and medication records because it is necessary to provide safe and high quality care to the client. Custodial staff or activity staff and volunteers are not authorized to see those records because they are not necessary to perform their job functions. Even if an individual is authorized to view and use PHI to accomplish their intended job function, they must take care only to use or disclose the amount of information necessary to complete the intended use. This is commonly known as the minimum necessary rule. For example, if a transportation company is transporting a client to a physician appointment, the transportation company employee may need limited health information to safely transport the patient in a way that accommodates their health needs. However, they likely do not need to know all the details about the client's health condition. The information disclosed should be limited to what is necessary to safely and effectively achieve the intended purpose of the disclosure. As a healthcare employee, you have access to patient health information in order to do your job. You have the obligation to only use that information for legitimate work purposes, such as providing healthcare services to clients or completing the processes necessary for your employer to receive payment for the services provided at the facility. Depending on your job role, you may also be authorized to share information with physicians or other individuals involved in the treatment of the client. Your employer may also use PHI for teaching new staff, conducting research, or ensuring the quality and safety of services provided in the building. It may also be appropriate for your employer to share information with individuals such as accountants, consultants, or IT specialists if the individuals are contracted to perform services on behalf of the facility. If your job includes helping with any of these functions, your employer will give you detailed information about what safeguards must be in place to use information for these purposes. Almost all other uses or disclosures of PHI require the client's authorization. However, please be aware that there are limited exceptions when information may be disclosed without authorization. These include public health and safety purposes and disclosing information to law enforcement under certain circumstances. You must never disclose information for these purposes without your employer's permission. If you receive a request for this type of disclosure, notify your supervisor immediately. We must all take simple and common sense steps every day to protect patient information. Your use of PHI will vary depending on your job role. Please be sure to learn and understand your employer's policies and procedures regarding how to protect PHI. Some common rules to protect information include: do not leave written PHI where it can be seen or taken by others. Do talk softly with coworkers. Do speak with clients and patients in private areas about their healthcare. Do not leave voicemails for patients and clients that contain PHI. Do not share information about clients or patients with others outside of work. Do not leave PHI at a computer printer. And do ensure that all paper client records are stored in locked areas when not in use. Electronic forms of communication and record keeping are commonly used in healthcare settings today. Any information that is stored or transmitted electronically is PHI. This means that we must take care to protect the privacy of electronic health information. Examples of electronic health information include electronic medical records, including physician orders, health history, and treatment notes, information shared via email, information stored on computer hard drives, information transmitted via fax, and digital photographs. Your organization has detailed standards and procedures to protect electronic PHI. Examples of safeguards your employer may use to protect ePHI include computer passwords, user access controls, automatic screensavers and screen locks, encryption of transmitted or saved data, physical protection of electronic systems, such as locks on computer server rooms and secured computer terminals. If you use electronic PHI to perform your work duties, you must be aware of your employer's specific security procedures. We all must take simple and common sense steps every day to protect electronic patient information. Your use of electronic PHI will vary based on your job role. Be sure to know and understand your facility's policies and procedures regarding the privacy of electronic PHI. Some common rules to protect information include: do not share your passwords, do not use the passwords of coworkers, do log out of computers as soon as you are done using them, do know your employer's policies regarding email use, do not post any information that identifies clients or patients on social media sites, and do not take photographs of clients or patients. In addition to protecting PHI from inappropriate uses and disclosures, HIPAA ensures that all individuals have the right to access their own PHI. Clients have several rights to access and control their own PHI. These rights include receiving a notice of privacy practices, inspecting and receiving a copy of their health record, requesting corrections of inaccurate health records, receiving a list of all uses and disclosures of their health information, limiting disclosures of their health information, and filing privacy complaints. In the next slides, we will review what you need to know to help ensure that clients are aware of their rights and can easily access their own PHI. The Notice of Privacy Practices describes how a health provider may use or disclose, including when information must be received prior to use or disclosure. The notice includes how clients' information will be used for treatment, payment, and healthcare operations. It also describes the limited circumstances when the client's information may be disclosed without authorization, such as for public health or law enforcement purposes. Every provider must abide by the terms of their Notice of Privacy Practices. The notice also explains how the client may request a copy of their health record or file a privacy complaint. Each provider must list the name and contact information of the person responsible for HIPAA privacy at their facility in the printed notice. This ensures that all clients know who to contact to request access to their PHI or report a privacy concern. All clients must be given the opportunity to take a copy of the Notice of Privacy Practices for their own use. Generally, clients must be offered the notice at the time of admission or before any health services are performed. All clients must be allowed to inspect and receive a copy of their health record. HIPAA requires that the individual's request be honored within specific timeframes. If the individual sees an error in their record, they also have the right to request that the record be corrected or amended. Individuals may also request a list of all the times their information has been used or disclosed by the provider. If you are aware of a client who would like access to their health record, notify your supervisor immediately. In certain instances, a client may request that their PHI be restricted from being used for certain purposes or disclosed to certain individuals. Examples of this include requesting that a particular family member not be given details of their treatment, that their name be withheld from a client directory, or requesting that their health insurer not have access to records for certain healthcare services received. All individuals have the right to file a privacy complaint with the facility and the Federal Department of Health and Human Services. If you are aware of a client who would like to restrict the use of their PHI or file a complaint, notify your supervisor immediately. In limited situations, healthcare providers may disclose PHI for health, safety, or legal purposes without a client's consent, such as in the case of suspected or proven abuse or neglect, to stop a serious threat to health or safety, such as an outbreak of infectious disease, or for a civil or criminal court proceeding. In these and other limited situations, it may be appropriate for your employer to disclose PHI. However, in each of these situations, your employer must evaluate the facts of the circumstance and decide whether the disclosure is permissible under HIPAA. For that reason, it is crucial that you never disclose PHI in these situations without your employer's permission. In some of these situations, time may be of the essence, so it is important to notify your supervisor of the situation or request immediately. Each patient has a unique situation, and our goal as health providers is to facilitate safe and high quality care delivery while also complying with the HIPAA privacy regulations. Sometimes clients are unable to make healthcare decisions for themselves. This can include deceased clients. It may be appropriate to share these clients' health information with a guardian, healthcare power of attorney, or other representative. However, the representative must have the proper authority. It is also often appropriate to discuss PHI with family members who are involved in the client's care. If you are unsure whether an individual has authority to receive PHI on behalf of a client, or whether you should discuss PHI with a family member, contact your supervisor. The impact of noncompliance with the HIPAA regulations can be severe for an employee and their employer. This is why we all have the obligation to comply with the HIPAA regulations. HIPAA noncompliance is a serious human resource violation. Violations are often mistakes that can be fixed through re-education. However, patterns of violations or disregard for the rules may be subject to discipline. Sometimes, employees may be disciplined according to their employer's discipline policies, up to and including termination of employment. Your employer's human resource policies explain the disciplinary processes at your organization. The federal government investigates privacy complaints and audits organizations for HIPAA compliance. Organizations may be fined large amounts by the federal government for HIPAA noncompliance. You may have read stories in the newspaper or have heard about HIPAA violation on the TV news. HIPAA is a federal law, and our clients expect us to maintain the privacy of their health information. For these reasons, the government takes violations very seriously. Technology can make our jobs easier, but it also results in new ways for information to be shared that creates potential for privacy breaches. Technology plays a big part in our work and personal communications. When HIPAA was first enacted, many technologies that are commonly used today did not exist, or if they did exist, they were not widely used. Examples of these include smartphones, iPads and tablets, Facebook, and Twitter. Email and texting have also become much more widely used than they were when HIPAA was enacted. For this reason, we must take great care to not let our use of technology compromise our clients' PHI. Technology is fast. We're able to type and send things very quickly. Before using technology to send PHI or post identifiable information, you must stop and consider the HIPAA rules. Some examples of inappropriate uses of technology are posting client names, descriptive information, or photographs to social media websites, or using your cell phone to take pictures of clients or client records. emailing or texting patients without permission of facility leadership, and sharing passwords or allowing someone to access electronic systems without employer permission are also examples of inappropriate use. If you see or suspect any inappropriate use of technology that has occurred at your organization, notify your supervisor immediately. If you are aware of an unauthorized use or disclosure of PHI, which is known as a breach, you must inform your supervisor immediately. We all have an obligation to protect PHI and follow the HIPAA regulations. However, sometimes honest mistakes are made, or sometimes employees ignore the rules. No matter what the cause of the breach is, it is important to report it to your supervisor. Reporting all breaches of PHI helps protect against negative consequences of the unauthorized use and helps to prevent future similar breaches. Failure to report a breach may be subject to discipline according to your employer's disciplinary process. What is a breach? A breach is generally the unauthorized acquisition, access, use, or disclosure of protected health information in a manner that is not permitted under HIPAA, which compromises the security or the privacy of the PHI. Under HIPAA, unauthorized use or disclosure of PHI is presumed to be a breach and is subject to investigation by your employer. Breaches can affect one or many individuals, such as a letter containing PHI being mailed to the wrong client, or an unencrypted laptop being stolen from the facility. In a few minutes, we'll review examples of PHI breaches. When a breach occurs, the healthcare provider must notify the individual whose information was disclosed inappropriately. This helps ensure that the individual can take steps to mitigate the harmful effects of the disclosure, such as monitoring credit reports if demographic or credit information was disclosed. If a breach affects a large number of clients, such as a stolen, unencrypted laptop, the healthcare provider must also notify the federal government and the media. Failure to provide notice can result in large fines and penalties. This is why it's important to report all breaches to your supervisor. What happens if you report a breach? Your employer will conduct an investigation of the suspected breach to decide if a breach did in fact occur. The individual or individuals affected will be notified, as well as the federal government and the media if that is required in that circumstance. Your employer will log the breach in the facility's privacy records and take steps to protect against any future breaches. This may include steps such as modifying facility processes or retraining employees regarding the facility policy. What happens if you report a breach? Your employer will conduct an investigation of the suspected breach to decide if a breach did in fact occur. The individual or individuals affected will be notified, as well as the federal government and the media if that is required in that circumstance. Scenario number 1. A family member of client number 1 sees the chart of client number 2 while an employee is completing their documentation duties. The employee may have been documenting when the family member walked up to talk with the employee, and the employee left the record open on the screen while talking with the family member. What can you do to prevent this from happening? When you see a family member approaching, close open records or lock the computer screen. This is especially important because often the family member will ask you to walk with them to the client's room. If the record is not closed and the screen is locked after you walk away, others may view the screen. It may be some time before you have the ability to return to the computer to complete the documentation. If you are aware that a breach has happened, what do you do? If you believe a family member sees the chart of another client, particularly if the family member had time to read the information in the chart, it was more than a fleeting glance as you were shutting down the record. Report this to your supervisor. Your employer may need to report this incident to the client whose information was viewed. Your employer may also be able to identify ways to help train staff to avoid similar situations. Scenario number 2. An employee shares PHI about a client with a friend or family member outside of the organization. This may occur as the employee is telling a story about their difficult workday and inadvertently uses the client's name or identifying information. What can you do to prevent this from happening? Healthcare is an exhausting and sometimes exciting profession. We must always take care not to share PHI with our friends and our family outside of work. Never identify a client by name, address, physical description, or description of their health condition. Even if you do not use the patient's name, someone overhearing your conversation may be able to figure out who you are talking about. This is a potential HIPAA breach. Also remember that this scenario often applies to conversations with coworkers at work and outside of work. Do not share PHI that is not necessary to perform your job. If you have a legitimate work purpose for discussing PHI with coworkers, do so quietly and respectfully. You never know who is in the elevator with you, outside the locker room door, or at the table next to you and may overhear your conversation. What do you do if this happens? First, notify your supervisor. This can be a serious situation that will require notifying the client of the inappropriate disclosure. The breach can have negative personal and emotional effects. It also frames the facility negatively in the public opinion. Your employer will need to retrain or discipline the offending employee and potentially mitigate the harm to the client and the facility's reputation. Scenario number 3. Employee number 1 gives employee number 2 their computer password. Never share passwords. Many employers determine health record access by job function or patient assignment. This is a common practice known as access controls. Sharing your password with a coworker who has different access controls can lead to a serious HIPAA violation. You may have access to records that your coworker cannot access under their own login information. This can create more problems for you than it will solve for your coworker. Additionally, you never want someone else logged into medical records or other work-related software as you. If they look at records they should not look at, make a mistake, document inappropriately, their bad behavior will be logged in the computer's security and privacy audit records as your bad behavior. If you are aware that this has happened, report it immediately to your supervisor, even if you only suspect that coworkers are sharing passwords. If you are comfortable approaching your coworkers about the situation, you should also remind them that this is a HIPAA violation and ask them to stop. Scenario number 4. A bill for client number 1 is inadvertently mailed to client number 2. The bill contains the client's diagnosis and information about the services they received. This can happen due to a computer error or a human error. If you are tasked with printing envelopes or stuffing mail, please be careful. Double check all information to ensure that the right patient information is associated with the correct patient and mailed to the correct address. You may also be able to suggest to your supervisor that your team puts in place internal control mechanisms to prevent errors, such as quality checking one another's work. If you are aware that an error such as this has happened, please notify your supervisor. Scenario number 5. This is our last one. An employee takes a photograph of a client on their personal cell phone. This is an example of how technology can be tricky in the healthcare setting. It is never appropriate to take a picture of a client using your personal cell phone or camera. Please note that in very limited situations, taking a picture of a client may be authorized by your employer if you receive the client's consent, such as for wound care documentation. However, in that case, it's not appropriate to take the picture using your own personal cell phone or camera. This concept applies even if you are friends with the client outside of work. When you are at work, your first duty is as a healthcare provider and you must abide by the HIPAA rules. Posting a photograph of a client on Facebook or emailing it to friends and family can be a serious HIPAA violation requiring discipline by your employer.